The cessation of outright conflict in northern Ethiopia, the political landscape of the Tigray region remains deeply fractured. Operating under the Tigray Interim Regional Administration, leadership, including Dr. Debretsion Gebremichael, has begun aggressively pushing for new, localized mandates to consolidate control. This political push materialized when the Regional Assembly enacted Proclamation No. 366/2018, officially titled A Proclamation to Ensure the Survival and Security of the Tigray People. The regional government framed the text as a necessary defensive measure to protect a vulnerable population. However, a close reading of the text reveals a different reality. Legal and constitutional analysts point out that the document extends far beyond regional administrative policy. The 44-page proclamation is a unilateral attempt by a regional government to rewrite federal criminal law. To understand exactly how the regional administration is bypassing the federal government, we have to conduct a strict article-by-article audit of Proclamation 366 against the Constitution of the Federal Democratic Republic of Ethiopia. Analyzing these mechanics reveals where regional authority overrides federal law, providing a case study in what happens when regional mandates supersede the national constitution. Ethiopian federalism allows regional states to enact local administrative regulations, rules governing municipal operations, localized trade, or regional services. It does not grant regions the sovereignty to write their own criminal codes. This legal ledger maps the boundaries of federal authority. On the left is the FDRE Constitution, on the right, the Regional Proclamation. Under Article 55(5), the power to enact a penal code is exclusively reserved for the Federal House. The Tigray Regional Assembly bypassed the Federal House entirely. By raising their hands, local officials voted a comprehensive, independent penal framework into existence. Looking at the ledger, we see how Proclamation 366 directly collides with federal jurisdiction. For example, Article 75 of the regional text creates entirely new localized informant laws and novel definitions for criminal behavior. This is a structural breach of the Constitution. A region cannot formulate isolated criminal procedures because criminal law requires standardized national application to ensure equal protection for all citizens. By drafting and enforcing a 44-page penal code, the Tigray administration commits jurisdictional usurpation. They are legislating with the authority of a sovereign nation rather than a federal state. The structural overreach compounds when examining how the law is applied through time. The proclamation relies on ex post facto legislation, the practice of criminalizing actions long after they have already occurred. Returning to the ledger, Article 22(1) explicitly prohibits retroactive criminal legislation. You cannot be convicted if the act was legal when committed. Under international and Ethiopian law, this protection is non-derogable, a human right that cannot be suspended under any circumstances. This timeline illustrates the proclamation's explicit retroactivity clause. The regional law stretches backward 5 years, criminalizing conduct all the way back to October 23, 2013, on the Ethiopian calendar. This look-back period subjects citizens to extreme legal jeopardy. Actions taken by individuals during the height of the northern conflict, actions that carried no criminal penalty under regional law at the time, are now prosecutable offenses. Permitting retroactive application provides the regional administration with a legal mechanism to launch arbitrary, politically motivated prosecutions against its own citizens for 5 years of past behavior. For a criminal code to function lawfully, it requires an independent judiciary to interpret the evidence and deliver verdicts. Our ledger outlines the architecture of justice. Federal Articles 78, 79, and 20 establish the absolute independence of the courts and guarantee the presumption of innocence. Proclamation 366 overrides these protections by explicitly stripping regional judges of their authority to acquit defendants. If a judge evaluates the evidence and determines the defendant is innocent, the new regional law legally bars the judge from declaring an acquittal. The outcome of guilt is predetermined by the legislation itself.
When a judge loses the legal right to find a citizen innocent, the entire foundation of due process collapses. The court ceases to operate as an impartial arbiter of evidence. Instead, it functions solely as an administrative arm of the ruling regional party, processing convictions on demand. By removing the power of acquittal, the Tigray administration eradicates the separation of powers and formally invalidates the constitutional right to a fair trial within its borders. Beyond restructuring the courts, The proclamation establishes strict behavioral controls, focusing heavily on individual expression and digital communication. The text explicitly criminalizes the expression of dissenting personal opinions. Furthermore, it outlaws the sharing or circulating of other people's written thoughts on social media platforms. This level of censorship directly conflicts with FDRE Article 29. The federal Constitution protects the right to seek, receive, and impart information of all kinds, in writing or through any media, without frontier restrictions. Regional authorities frequently claim that localized crises grant them the power to temporarily suspend civil liberties for the sake of public order. Legally, this is false. This flowchart maps the lawful architecture for suspending human rights. The regional path is blocked. Rights can only be suspended through the highly regulated federal pathway of Article 93, a state of emergency. Proclamation 366 attempts to force its way through a non-existent regional loophole. Utilizing regional law to execute emergency-level censorship allows the local administration to bypass the federal legislature, deploying legal threats to suppress political dissent without oversight. The consequences of this legal overreach extend past the courtroom and digital spaces. They mandate severe physical consequences for the local population, specifically the youth. Under the guise of securing the region, the administration has implemented daily roundups, forced conscription operations designed to draft citizens in preparation for potential future conflicts. To maintain this conscription pool, severe restrictions have been placed on outbound travel. Citizens report that securing bus or plane tickets out of the region has become functionally impossible without administrative approval. These physical constraints violate two core pillars of the Constitution. Article 18 explicitly prohibits forced labor, and Article 32 guarantees every Ethiopian the freedom of movement. The humanitarian result of these colliding legal forces is mass displacement. Citizens are attempting to migrate away from the regional administration to escape jurisdictional overreach. Enforcing localized conscription and confinement outside of a federally declared emergency is a direct violation of constitutional physical liberty. This completed audit defines Proclamation 366/2018 as a systematic dismantling of FDRE federalism, executed across 5 distinct legal categories. The Regional Assembly has usurped federal criminal jurisdiction, enforced retroactive punishment, stripped judges of their independence, criminalized free speech, and restricted physical movement. This brings us to the final, overarching legal mechanism built into the Ethiopian legal framework, FDRE Article 9, Subarticle 1, the supremacy of the Constitution. The explicit rule of Article 9 is absolute. Any law, customary practice, or decision by a state organ or public official that contravenes the Constitution is automatically invalid. As this visualization shows, applying Article 9 to the regional legislation renders a clear verdict. Because it contravenes federal jurisdiction, Proclamation 366 is legally null and void. Yet, despite being constitutionally void on paper, the regional administration continues to actively enforce the proclamation on the ground. The federal government has so far failed to issue an official response or intervene to strike down the legislation. This silence creates a de facto legal vacuum. In the absence of federal enforcement, raw political power has replaced constitutional due process within the region. Until federal supremacy is explicitly reasserted, this legal vacuum will continue to deepen regional instability, subjecting the Tigray population to unauthorized laws and intensifying their humanitarian anxiety.